Okay, in the matter of People versus Eric Martin. Mr. Martin, can you hear us?
Yes, can I get the first case number of the so-called case that never was given a copy of the ticket by the police officer, which he should have in violation of my due process right?
241388 SM.
241, what else?
38 SM.
38
1388 SM.
24138 SM. Right?
Yeah, 2 weeks.
Okay. All right, thank you.
I do have in front of me a complaint charging with domestic violence violation of city code. It's misdemeanor. Oh, I see, January 24th, January 10th. Okay, you pleading not guilty, Mr. Gazicki?
That's John James Gazicki. Mr. Martin expressed his right not to be represented by a court-appointed attorney. He wishes to represent himself.
Okay. Is that right, Mr. Martin?
Present myself, yeah.
Okay.
Because I don't want to give up my right to be one of the sovereign people, as the U.S. Supreme Court said I have a right to be. So.
Okay. I'm going to let you do that. I don't care why. Have you talked to the prosecutor?
No, I have not.
I want you to get the prosecutor and have her talk to Mr. Martin, and let's see what we're going to do today.
All right, so I would like to talk to him right about how the case should be dismissed based on there's no.
Before we get too far, let's set the stage. What you're about to witness is a classic sovereign citizen clash with the justice system, one that highlights confusion, misplaced confidence, and the consequences of believing internet mythology over actual law. Our defendant, Eric Martin, claims to be a living man, not subject to the same rules and legal structures that govern everyone else. This mindset is incredibly common among sovereign citizens. They treat statutes, case law, and courtroom procedure as optional, and then seem surprised when judges disagree. This hearing also comes after Martin spent over a month in jail on a domestic violence charge, one of several cases he's racked up across Michigan. He believes law enforcement has no authority, judges are violating his constitutional rights, and that he can unilaterally demand the court arrest its own officers and judges. Spoiler alert, that's not how anything works that ASU watch. Pay attention to the strategy. Refusal to answer direct questions, redefining legal terminology, and demanding fictional rights. It creates chaos where there should be clarity. But judges have seen this play countless times, and they're more than ready to buckle up. Today, you'll see jurisdiction arguments, attempts to disqualify judges, conspiracy-grade reasoning, and the constant insistence that he's innocent because he simply says so.
A matter of People versus Eric Martin.
Okay, thank you.
Mr. Martin, can you hear us?
Yes, I hear you.
Okay, Mr. Prosecutor, want to put your appearance on record?
And good morning, Your Honor. Omar, or good afternoon, Your Honor. Omar Shah on behalf of the people, PA 6332.
Okay. You've had an opportunity to talk to Mr. Martin?
That is correct, Judge.
Been able to resolve this matter?
Judge, there is no resolution on this matter. I had an opportunity to speak with the defendant in this case. He wishes to have a jury trial or a bench trial. He just doesn't know which one he wants.
Okay, Mr. Martin, which one do you want? I'm going to set this over for a trial. You want a jury or the judge to hear it?
Well, I don't really want to answer that question. I don't want to be fraudulently presumed I'm consenting to any of these proceedings. You know, I'm not consenting to have my right against slavery violated by consenting to any proceedings. So that's why I kind of want to answer that question. But before I get to, as I notified the prosecutor, he should have dismissed the case due to lack of evidence. But I had one more thing I wanted to point out to the prosecutor. I forgot to mention to him. I want to mention to him now, and that is I want the police officer, Bardaway, who illegally arrested me. I want him charged for the legal arrest, which is assault and battery. And also Judge Shackelford, who did not give me a personal bond. I want her arrested too for violating my right against kidnapping and allowing this unlawful incarceration of me, which I have a right to do. And if they refuse to do it, I'm also going to move for dismissal on the case because it's violating my right against equal protection, because I have the right to have charges brought against people who have committed crimes against me also.
Right out of the gate, Martin attempts to derail the proceeding by asking for the case number and claiming procedural violations. This is a common sovereign strategy. Focus on paperwork technicalities to imply the whole case is illegitimate. In reality, even if an officer failed to hand him a physical ticket at the moment, it wouldn't magically erase the charge. Courts maintain records, and the complaint exists regardless. Notice how the judge calmly acknowledges the charge while refusing to be pulled into debate. That's key. Sovereign tactics rely on confusion. Judges rely on law. Big difference.
Okay, based on that, I'm going to indicate that you want a jury trial. I'll set this matter over. I'll have the assignment clerk set a date. She'll send you a notification of the date for the jury trial. In the meantime, I'm going to continue your bond until that day. You go with the sheriff, he'll take care of you today.
Hold on, objection. I have a motion to make that I have a right to a personal bond.
You file that motion in writing, and I'll take a look at it.
I already did file it with the.
In the meantime, I want you to go with the sheriff, and he's gonna take care of you.
Hold on, object. I have some. I already filed it. I'm making that motion now. I'm making that demand actually now because it's a constitutional right to be innocent without guilty. All right, then I'll be taking your job. How about that? Because you violate my constitutional right, and I move to dismiss you off the case, disqualify you. Since you violate my due process right to a personal bond, then you showed your biasness, and you should not be in the case no more. I move to disqualify you. If you deny that motion, I request that you send it to the State Court Administrative Office. You're not supposed to continue my bond with monetary award. Shackelford illegally denied my personal bond, and you're not supposed to continue that illegal denial. I have a constitutional right to be presumed innocent, and that means the right to a personal bond. Article 3, Section 1, judges that violate the Constitution cannot hold office. So don't grant that motion if you want to, that demand. I'll be to get your job in a lawsuit. That's all I got to say. So you want to continue with that? Sound like they muted me, maybe. Well, these judges are going to find out. They're not above the Constitution.
Here, Martin refuses a court-appointed lawyer because he thinks accepting one would fraudulently presume legal status. This stems from a misinterpretation of corporate personhood. Sovereign citizens believe their government-issued name is a fictional corporation. They think avoiding attorneys, licenses, and signatures keeps them separate from government control. Ironically, rejecting a lawyer almost always hurts them. Proper representation could clarify rights, evaluate evidence, and negotiate favorable outcomes. Instead, we see someone intentionally handicapping himself in a system built on procedure. Sometimes, the most sovereign thing you can do is accept help.
1510, people of the city of Taylor versus Eric Martin.
Jeffrey Fanto, the court asked me to verify that Mr. Martin would be presenting himself without the assistance of attorney. That appears to be his position, Judge.
All right, so Mr. Martin, you are waiving the House Counsel?
Yes, so I'm not fraudulently assumed to be the defendant, a living man, not the legal fiction corporate entity defendant, which I couldn't possibly be. I know due to canon law being, unfair, you guys fraudulently assume that if I take an attorney. So that's the unfairness why I can't accept attorney because of that.
Sure. All right, and you understand all of your constitutional rights?
I do my best to. I've been studying, practicing law 28 years.
All right. That's all right. So looks like this is ready to be set for a jury trial. Is that right?
Yeah, but I want a jury trial of my peers means of the sovereign people, not U.S. citizen slaves who most probably everyone of the jury probably say they are. So.
This moment highlights the dangerous escalation of sovereign reasoning. Martin not only rejects jurisdiction, he demands the court arrest law enforcement and another judge. He's misapplying the idea of equal protection, twisting it into carte blanche to prosecute people he personally dislikes. Courts require probable cause, sworn statements, and actual statutory violations. You can't just declare crimes into existence. This is where sovereign rhetoric becomes self-defeating. The more aggressively he pushes imaginary rules, the more credibility he loses. Remember, allegations aren't evidence. Accusations aren't charges. And confidence isn't legal authority.
And I'll determine that. So we will have this set, and then I'll mail out the date for the jury trial.
I believe there's a date set for next Tuesday for the jury trial in this matter.
All righty, I see that.
I have objections about, I cannot probably prepare for trial in this jail. I've been illegally denied my constitutional right to a personal bond, even though it's my constitutional right because it's part of my right to be innocent before guilty. It's been denied so far. I have no money to pay for a bond to get out of here. So that's especially why I also should be given a personal bond. And like I said, I cannot probably prepare for one in here, you know?
So you're in there for a different matter, because I set your bond at $100 personal before on this matter. So it's whatever's keeping you in jail isn't this case. So we'll see it. I understand though that you do need to prepare for trial. I get that part. So we'll go ahead and adjourn the jury trial. When is your out date? With whatever you're doing there.
There's no out date. That's the thing. It's So is this about the moped case?
Yeah, this is driving while your license is suspended.
I wasn't sure, right? They got me legally confined right now in the domestic violence. No evidence at all. She lied, made a statement, so now
hold on, Mr. Martin, hold on. Even though this is a different court and that's not my case, you have the right to remain silent. Anything you say can be used against you. I just want to advise you of your Fifth Amendment right again. So I suggest not bringing up the other case. This case here is on the moped and the driving on a suspended license, or revoked license.
Okay.
So what I'm saying is you need time to prepare on that one. I don't know what the situation or status is of the domestic violence case, but you said that you're on bond. You haven't posted your bond on that case. Is that what you're saying?
Well, I'm not even sure. I think the judge said a monetary bond. I wasn't sure because she unprofessionally drew the thing away from, the remote Zoom thing away from the door before I could read the hearer. But it's not like she told the police officer $2,000, but I'm not even sure. I got no money to pay a bond, no way, even if it's $1. So
this section is sovereign citizen strategy distilled. Martin floods the court with objections, threats of lawsuits, motions to disqualify the judge, and claims of constitutional violations. Sovereign ideology teaches that if you refuse to consent to proceedings, the court loses power. It's legal fantasy. The Sixth Amendment guarantees representation, not immunity. Judges can deny personal bonds based on risk, severity, and safety concerns. Threatening a judge's job isn't persuasive, and invoking Article 3 incorrectly doesn't override jurisdiction. The irony? In actual constitutional law, these behaviors can hurt you at sentencing. Judges remember disrespect.
I am allowed. I don't have nowhere else to live. That's my house. I'm allowed there. You ordered that illegal. That violates my due process.
All right. He has a $2,000 cash bond with a GPS tether.
Yes,
and he's not to return.
Personal bond.
He's not to appear at 9.
Without guilty.
He cannot come to 9074 Clifford or be in contact with Crystal Martin.
So, right, because they illegally denied my personal bond, this is why I'm still in here. So, but yeah. So,
all right. So what I'll do is, I don't know when that case is next. The next day, is that it's a state case? Ms. Manarino, you don't have that case, right?
I don't
so
know
it must be a
anything
state. All right, and so it must be a state case, which means it's on a Monday. So that's probably going to be resolved within a month. So let me go ahead and set this for jury trial. No, there will be no need to set it for a settlement conference before that. But
Well,
let's
I
get
object
a
to that. I won't catch up. I was going to object before you guys don't give me a chance to talk. I object to like it should be. I moved that to be stayed. This moped case till I get out of prison. I mean, till I get out of jail here. I can prepare myself. I can't probably prepare myself.
Right, that's right. Listen.
Ask some of my legal
Listen.
authorities to
Mr.
argue about nothing.
It's being set for a jury trial.
The other one
Case
is?
from yesterday.
Okay, so when is that one?
They didn't set it.
Okay. All right, so I'm gonna set it for a jury trial, but if you're still in jail at that time, then I'll just adjourn it again so that you can prepare. I'm not worried about that. So, I mean, but I can't do anything about your other case is what I'm saying. So I'm looking at, as far as a date right now, I just want to put a date on the books so that we know that you have an idea. I mean, if you get out tomorrow, then you'll know and then what your date is. So I'm looking at, let's see. And I don't have the availability to check with my clerk because my criminal clerk is out this week.
Your Honor, we do
So
have
I'm
other,
go ahead.
I'm sorry, Judge. We do have other jury trials scheduled on your docket on July 9th. I don't know if that's too soon.
That's probably going to be, and it's only a couple weeks away. So I don't know what his situation is. And even if he gets out in a week, that only gives him a little bit of time. I want to make sure he has at least a couple weeks to, I mean, it's a driving on a restricted license. So it's not exactly a whole lot of prep time for that. It's not a homicide case, but
Another classic misconception, the idea that a jury of peers must be ideological equals, specifically sovereign citizens. In reality, peers means fellow members of the community, regardless of beliefs. If everyone could handpick their jury based on shared worldviews, trials would grind to a halt. Imagine burglars insisting on juries composed solely of other burglars. That's how absurd this request is. The judge's calm response, "I'll determine that," shows firm boundaries. Courts define legality. Personal philosophy doesn't rewrite jury standards, no matter how passionately someone believes it.
13th. Because I'm trying to pick a date that's outside of probably where I'm already scheduling stuff at, because I don't have my criminal clerk here to kind of check and see like where I'm at with things. So we're going to set this for August 13th.
Thank you, Your Honor.
And I know that we'll set that at 8:30 in the morning, August 13th. All right. Mr. Martin, let the deputy know that you're all set, and we'll be mailing out the notice to you, sir.
Thank you, Your Honor. All the best to you and your staff.
Say again?
That's something I want to say to, okay, with the prosecutors here. Dealing with this other case that I'm here for now, I request that.
Not the same prosecutor. Not the same prosecutor. That's the state prosecutor.
They're Taylor prosecutor.
Your other case, are you talking about your other case? Your other case is a state case. So that's a Wayne County Prosecutor's Office.
No, sir,
Not the city attorney.
I'm talking about
Okay.
the case I'm in here now. I want them to notify the prosecutor that I want charges filed on Crystal Martin for bringing these falsified charges against me now. And also for assault and battery that I have on video camera for. Just so, you know what I mean? And she keeps bringing this.
Again, that's the other prosecutor. That's a different prosecutor's office, sir.
Because it's my equal protection right to bring charges too. They want to bring charges against me, but they don't have no evidence. I do. And I should be suffering here in jail as a lack of evidence as a result of my and the unequal protection clause.
And that's on your other case, sir. So,
But it's still a right though. It's still my right to tell the prosecutors this and have them act on it. And if they
No,
don't,
this
that's
isn't-
going to certify a defense.
This isn't the proper prosecutor. That's the Wayne County Prosecutor's Office on your other case, okay? This is the city attorney. Okay? Deputy, have a good rest of your day to you and your staff.
Thank you, Your Honor.
Thank you, Your Honor.
This commentary calls out misinformation directly, and rightly so. Martin claims he didn't hear the bond ruling because the judge unprofessionally moved the camera. Footage proves otherwise. This exaggeration tactic is common in sovereign circles. When facts don't support the narrative, they're reimagined. The bond with GPS tether is standard in domestic violence cases, especially where victim protection is prioritized. Sovereigns often insist they're jailed for victimless offenses, ignoring real impact and alleged harm. But here, the system prioritizes safety, not ideology. Courts act on evidence, not self-declared innocence.
To set aside, let me bring them up. People versus Martin, case 241388 SM. Today's the date and time set for a settlement conference. Also, there was a motion by Mr. Martin, motion to dismiss the case. Court has read through the motion. There was no accompanying brief in support. Well, there's also objections to the denial of the personal bond. I'm going to consider that as a motion for reconsideration. All right, Mr. Martin, was there anything else you wanted to place on the record, sir?
Oh, yes. Well, first, I'm not the fraudulently assumed defendant. I am a living sovereign man.
I can see that you are a living man. You are currently talking, and we are having a conversation. So, okay.
Right, but John, under the law, there's fraudulent presumptions under canon law 3228 that, that say otherwise, and there's a lot of support what I'm saying. So that's why I say what I say to the record. But anyways, yes, I do have other things to say. First, I also want to file a demand to dismiss this case based on speedy trial violation under Mission Court Rule 6.004C, 28 days for speedy trial in misdemeanor cases. I've been in jail over that since the 8th of last month.
And there we have it. After multiple attempts to derail the proceeding, redefine legal terminology, and demand arrests of officers and judges, the court stays grounded and proceeds by the book. Martin's request for sovereign jurors is denied, his objections overruled, and his preparation concerns addressed responsibly. The judge ensures he'll have adequate time to prep while maintaining focus on the actual case, driving on a revoked license. This hearing showcases an important legal truth. Personal belief systems don't override jurisdiction, statutes, or courtroom procedure. Courts operate on verifiable evidence, not ideology. So what do you think? Are sovereign citizen arguments bold defenses or self-inflicted setbacks? Backhand index pointing down, drop your thoughts in the comments. If you found this case as shocking as we did, hit that like button, share your opinions below, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Share this video to help others understand the real-world consequences of challenging the legal system with internet myths.
And also, go ahead and also want to say, I ask that you give me all the time to speak, say anything I want to say, instead of like shutting the court proceedings off that's happened before. Make sure I'm done with everything I have to say. But that's it for right now. But like I said, I might just say depending on what you say in response. So.
All right. Well, your motion to dismiss is denied. Your motion for reconsideration with regard to personal bond is also denied. Are we setting this for a bench trial or a jury trial?
Before I ask that question, I have to respond now to your denial. Now, based on what reasons are those denied, I have things to say in response to that.
Well, sir, I'm not cutting you off, but there's nothing, it's my ruling. If you want to file a motion for reconsideration as to anything, you're more than welcome to follow the court rule and do so. But there's really nothing to add to my ruling. So
I'm asking the reason. I'm not asking what are the reasons that the bond, for example, is denied? Okay, first of all, what reasons is it being denied?
I've already stated that last time, sir. So are we at the next question here is, do you want a bench trial or a jury trial?
Well, I have more to say in response to
do you want a bench trial or a jury trial, sir? Stop avoiding the question.
I just want to take off jury.
Jury trial. All right, we're going to set this for a jury trial.
But I want to make it clear, I'm not consenting to
you'll be given notice of when that will be, sir.
Okay, I'm not consenting to the jurisdiction of the court still, and